Hello everyone, and welcome to the podcast for week 4 in our course on international business. Last time we reviewed the various regimes which regulate trade, whether it was trade in goods or trade in services. This week, in this section, we're going to begin to look at the mechanics of trade. We're going to do that by examining how sales are regulated under international law, and how goods that have been sold are transported between buyers and sellers, and very importantly, who bears the risk of that transport. Now, as I've repeatedly stressed throughout these lectures, in all transactions, but particularly international transactions, where the parties operate in different legal regimes in different countries, and where they don't always have a sense of what the credibility and responsibility of their trading partners is. What the law tries to do in these situations is to establish reliable expectations so that individuals involved in transactions have enough of a sense of security to proceed. In short, the law seeks to mitigate the risk of doing business internationally by creating common, legally enforceable understandings among the trading partners. And that's what reduces the risk. People have an expectation of how their trading partners will behave based on the law. Now, the primary international law regulating the sale of goods across borders is the UN Convention on Contracts for the International Sale of Goods, known as the CISG. It was adopted in 1980, and its purpose is to provide a comprehensive set of uniform rules applied by all member states and which contracting parties can rely on as binding. As of 2014, there were 83 states that had adopted the CISG. We have many significant participants. Some have only joined recently. Countries like, for example, Brazil joined in April 2014. They're currently the 23rd largest exporter in the world. Japan, the 6th largest exporter in the world, joined in 2009. We also have major powerhouses, Germany, the United States, and China. But still, there are some significant players in the international trade market that have yet to adopt the CISG, including the United Kingdom, the 5th largest exporter in the world, and India. Now, India is currently the 19th largest exporter in the world, but is projected to be, by 2050, the 2nd largest exporter with a projected 8.4% of all global trade. So those are some big countries that aren't members of the agreement. And the pressure is on to get them to try to join, and we'll see what happens over the next decades. Now, the CISG applies to all contracts involving the sale of goods under certain conditions. One, it applies to the sale of goods between parties whose place of business are in different states, so you have an international transaction, when the states are contracting states. That means if both states are members of the CISG will apply. But could also apply in one other instance, and that's this kind of confusing language down in sub B, where it says, when the rules of private international law lead to the application of the law of a contracting state. And what does that mean? That means that if the contract itself says that you are to apply the law of a particular state, and that state is a member of the CISG, then the CISG could apply, unless that state has made a reservation to the treaty. Now, this is a pretty hard thing to understand, and it's important, so I do want to give you a bit more of a detailed discussion on this issue, and let's do this through an example. Let's say that we have two businessmen. One is from the United States, and let's put the other one from Germany. So the question, they enter into a contract for the sale of goods, and the question becomes, does the CISG apply? Well, we know that both the United States and Germany are both members of the CISG, so yes, the CISG would govern the contract. Easy one. Now, let's change the scenario a little bit. Let's put our businessman on the right over here, the jolly man with the briefcase. Let's say he is not from Germany, but instead he is from the United Kingdom. Now, the UK is not a member of the CISG, But, as we just talked about, the treaty still could apply depending on A, what the contract says, but it also depends on what the law of the parties say. So let's start with the very simple terms. If the contract itself says that the law of Britain or the law of the United Kingdom applies, well, the United Kingdom is not a member of the CISG, so no, the CISG would not govern the contract. But let's change the scenario so that the contract says that the law of the United States applies. Now we remember under Article 1, if the law of the United States applies, it is a member of the CISG, so we would have a rule of private international law, the contract telling us to apply the law of a member state. This is where we have to look at what the United States said when it signed on to the treaty. If you think back to when we talked about treaties, we discussed the concept of a reservation. Now, a reservation is a statement that we're not going to abide by one part of the treaty. So what did the U.S. do when it signed the CISG? Well, the United States said, we don't particularly like this section of 1B here. Pursuant to Article 95, the United States will not be bound by subparagraph 1B of Article 1. So what does that mean? That means that under U.S. law, both countries must be members of the CISG for it to apply. So the CISG would not apply here. It would not apply to the sale, or for that matter, it does not apply to the sale of any goods internationally between a U.S. company or a U.S. person and another country that is not a member of the CISG. Under U.S. law, both parties must be members or must be citizens of countries that are members of the CISG. But let's tweak our facts one last time, and let's say that our friend on the left here is not from the United States, rather he's from Canada. Now Canada is a member of the CISG, and it does not have the same reservation in its treaty. So if the contract says that they will apply Canadian law to the agreement, and Canadian law adopts the CISG as it does, then even though our friend on the right here is from a non-member state, the CISG can still apply. It's a bit of a complicated topic. Take your time with it, go through the readings, and make sure you understand, and let me know if you have any questions. Now, the CISG, it does not regulate all aspects of contracts. Many of the most important issues are indeed left to domestic regulation. The CISG only seeks to establish uniformity across the various legal systems with respect to issues of contract formation and remedies for breach. It doesn't address questions of legality, what type of contracts may be entered into, or competency, who is capable of entering into a contract. Doesn't address questions of third-party rights or even certain issues of liability for personal injury. All of those types of questions are left to domestic law, which regulate the contracts. Now, this is a crucial issue because where the CISG does apply, it preempts or it trumps domestic law. And of course, it has to if you're going to have a uniform system of laws between multiple countries. That system of laws must be superior to the domestic law. So it does do that, but it doesn't cover all of contract law. As for the substantive parts of the law on contract formation and breach, those are the basic principles you've already learned. Basic principles adopted by most legal systems around the world. I'll leave you to read about them in the readings in the books this week. Now, after you buy or sell the goods, the next critical phase you have to worry about is the transfer of goods between the buyer and the seller. In international trade, that distance that you have to transport goods is often quite substantial. And transportation, indeed, has become a major issue. International law has developed a series of rules about transportation of goods designed to try and mitigate the risk of transport. Because, let's be honest, transport can be risky. Anytime you're moving goods from point A to point B, you run the risk of damage or loss. Now, because of these risks, a series of laws and regulations have developed to assign responsibility, to create common understandings in the industry as to the meanings of certain terms. These are known as trade terms. Now, the terms can be defined by the parties themselves, or they can be based on a set of predetermined rules, like Incoterms that are adopted by the International Chamber of Commerce. Now, trade terms generally are divided into general groups identified by letters, and they provide standard terms of contracts, such as the time and place where buyers to take delivery and pay for the goods, costs of freight insurance, who bears that price, when the risk of transportation shifts between the parties. Now, when that risk shifts between the parties is crucial, because this is the period of time where neither party is in possession or control of the goods. Rather, the goods are in transport. As a result, who bears the risk of the loss is not immediately apparent and must be spelled out in the contract. So, what Incoterms do is try and set a standardized system where parties can understand when that risk will shift. And they're divided into, as I said, kind of various letter groups. In the F series, where we have, and I'll warn you, some of the language in this is a bit strange. We start with FCA, which is an abbreviation. It means free carrier. It means the seller is responsible for getting the goods, getting them through the export, sending them to the carrier, but at that point in time, the buyer's obligations are green. As soon as it gets off the carrier and to the port for delivery, then the buyer takes the risk. The buyer has to pay and bear all the risk to get to the goods here. Free alongside ship names the port of shipment. So here the seller has to get the goods through export customs, onto a carrier, onto a port, and on right next to a particular ship. Free alongside the ship. So just next to the particular ship, as soon as it's there, the buyer takes responsibility for getting it on board and getting it to himself. Free on board takes the next step. That means the seller has a responsibility to go through export customs, get it onto a land carrier, get it to the port, and to load it onto the ship. Once it's loaded onto the ship, the buyer takes over responsibility for getting it off, bringing it to the named place, paying import duties, and getting it to his business. That's the F series. The D series places a lot more responsibility on the seller. So at the D series, you can have something delivered at the terminal, where the seller is responsible for taking the goods all the way to a particular named place, a terminal, usually near the docks. They can be required to deliver to a particular place. That means they will get it all the way through to a particular named place. Finally, they can even agree to pay the duty and deliver it all the way to the buyer. And if you think about the way normally goods are shipped when you're buying consumer goods, this is what often happens. You know, if you contract and you buy over the internet a good, that good will be sent to you and it'll be all the way delivered to your place. That means the buyer or the seller is responsible for import customs, transportation when it gets to the United States, as well as delivering it to the buyer. That's the D series. The E series is the opposite. It is the least restrictive on, or at least imposes the least obligations on the seller. Basically, the seller says, I have it at my place of business, and the buyer is responsible for picking it up and shipping it back home. And they're called E, and it refers to X works at the named place of delivery. You just are responsible. The buyer has to pick it up. Finally, we have the C series, and this is an interesting one because it allows certain costs and risks to be split. Cost and freight at the named port of destination. So here the seller takes it all the way to the port, and including pays the cost of the freight to get it onto the truck to have it delivered. Although the buyer bears the risk of the loss when it is being taken off the ship, the seller pays for it. If it's cost, insurance, and freight, same idea, except the seller here is actually going to have to buy insurance for the unloading process as well. Carriage paid to, CPT, means that the seller will deliver the goods to the port to be delivered, pay for them to be delivered all the way through to import customs, which become the buyer's responsibility. But at this point, the buyer maintains the risk of loss during this period. The seller is simply paying the shipping fees, not the insurance fees. We'll talk about that in a second. The seller simply pays the shipping fees. The buyer is responsible for risk in purchasing insurance. And finally, we have carriage and insurance paid, and that's where the seller will pay the insurance all the way and freight charges all the way to import customs, even though the buyer will bear the risk of loss. So those are your general Incoterms that if you get involved in international trade, you will certainly run into these almost in every contract. Now, the primary means of shipping goods is still by sea. Some occur by airplane, but that's incredibly expensive to do. And obviously, ground transportation and rail transportation is limited to contiguous states. So the primary means of shipping is by the sea. And there are a variety of rules and regulations that have developed to regulate this type of trade. There are many different ways you can do it. You can have common carriers where you share space. You essentially just rent space on a cargo ship, and I go through different types of common carriers in the books. Or you could have a charter party. That's where you actually rent out an entire ship. Again, there are different costs and rules associated with that. The primary document you're dealing with is the Bill of Lading. This is the document which governs the rights and responsibilities of the party. It also serves as the title to the goods. The buyer will need it to claim the goods when they arrive. We'll talk more about some bills of lading next week when we talk about finance. Okay, that's it for this week's short introductory podcast. Next week, we do move on to a discussion of how to finance trade in the international marketplace. So go on, read the lectures and the text, and I will see you on the discussion boards.